Let us start. Dear participants, dear friends of the Fide and Transatlantic IP Academy Global Digital Encounters, it's a pleasure, it's an honor to be with you today. First of all, Happy New Year. We are just on time still to say it so, January. And it's a pleasure to be again together for the 41st edition of this project, started more than 5 years ago now, and that tries to review in a non-conventional way what are the outcomes of the intellectual property system, what are the limits, what can be constructed together, and also that tries to build synergies and networks of friendship among all of us, among speakers and participants. This project, the Global Digital Encounter project, is a project that is, of course, quite successful because it is 5.5 years old. And it is a project that is a pro bono one. I always insist on this. There is no, absolutely no, never any remuneration or whatever for the speakers. This is something that is made to enlighten the academic and professional community on intellectual property challenges, on intellectual property outcomes that always have challenges. And this connects very much to today's objectives. Today, we shall discuss patents as a key tool for innovation and economic growth. This is a very crucial moment for many economies that are in projected, all of them, in a way or another, in an international race. Sometimes people say in an international turmoil. It is therefore very important to see how patents play a role, why and how patents are key tools for innovation and economic growth, what was achieved, how it is achieved, and this is why for this very Global Digital Encounter, I gathered as director of this program, together with our Fide friends, I gathered an exceptional panel of speakers. Speakers who have very large, wide expertise on intellectual property matters with specialization on patents. We have with us the honor to have the chief economist of the European Patent Office, Professor Yann Menière. We have with us Axel Ferrazzini, who is the managing director for IP Council for Europe, and a very, very successful NGO that produces neutral research on intellectual property to serve stakeholders in Europe and in the world. So we are very happy to have both of them with us. And we have with us Frederick Edman from the University of Lund, but from the section that relates to promoting precisely innovation. Therefore, he's not only a maker, but also a user and a customer of the tools that exist, the patent tool that exists. And the three of them have a lot, hopefully, for sure, to tell us and to share with us. So we remember the rules of the Global Digital Encounter, which is that for the first 30 minutes, our speakers reply to questions that I have prepared for them. And then we may continue or we may jump on the questions that you, distinguished audience, will raise in the chat that I shall monitor as moderator of this Global Digital Encounter. I would wish once again to thank all our pro bono sponsors for this activity, which permits us to do something in full academic freedom and in full ethical freedom by all ways. So I am very, very proud of this very context and want really to thank all those who are next to us, including and above all our audience. I would propose now to start formally the encounter, and I have a first question to raise. And the first question is for Jan. Why and how patents serve as a key tool for innovation and economic growth? Can we say this today? And if so, why and how are patents such tools? And I'm sure that his colleagues would wish also to rebound on this question. Jan, the floor is yours.
Thank you, Laurent, and good morning, good afternoon, everyone. So I would, the very short answer is that patents are important to innovation, and innovation is important to economic growth. Let me start with the second part. There are some studies assessing the impact of innovation on economic growth. I would quote one published in Econometrica, the best possible journal in economics, showing that investment in research and development generate a 21% return for the investors and a 55% return for the society. So it shows first that the return on investment on investing in innovation in R&D is quite high for companies, 21%, that's high, but it's twice higher for the society. And this is because research investment generate information, knowledge, and this knowledge can be reused very easily once it's there by other parties. And actually, the fact that the social return is higher than the private returns mean that we never invest enough in innovation. And actually, an impediment to investing in innovation is that once you have innovated something, it can be easily copied. And this is where intellectual property and patents come into play as a device, as a legal tool, actually to help investors in research, inventors, to appropriate the value, the return on their R&D investment, on their inventions, and to market them to the society. So in that respect, patents, like other intellectual property rights, have a first function of protecting inventors, creators, from being copied, and thereby incentivizing them to invest in creation. But that's not the end of the story. Actually, patents are intellectual property rights. They are assets. And when you have an intellectual property right, it's much easier to exploit actually your idea, your invention in the case of a patent. So when the patent system is a contract between the inventor and the society. In exchange for getting protection, getting exclusivity, the inventor has to disclose the invention, which makes it visible, creates a register for third party to see. And that can be the basis of a licensing agreement. That can be the basis of collaborations. That can be a way to attract and secure investors. So besides being a fence against being copied, patents are also a bridge to collectively organize the economic exploitation of inventions. And that's increasingly important today because it's increasingly said innovation does not take place in silos. It starts in universities, then it has to be licensed, transferred somehow to startups, then to larger companies, etc. And you need patents to organize these transactions.
You know what? I will add something about this because this introduction is just perfect. We know that most companies, big and small, believe in patenting. Some do it on a systematic manner. You know, they strongly believe in patenting. But some of the small companies, and at For IP Council, we try to really educate all the stakeholders. We realize that smaller companies do not really understand how strong a patent can be. And the best example is some companies say, oh, but you know, what I'm doing might be useful just for a few years. Might be useful just for a few years. However, we never really know. You know, maybe if you file a patent today, maybe in 15 years, that will have different usage that the inventor didn't think about before. So protecting is the first step. Then there is no obligation. That's not mandatory to monetize the patent. It is recommended, of course, but some companies and individuals may choose just to protect, and then they have the opportunity to decide: do I want to give licenses for free? Do I want to monetize my patents? that's up to them. So I think that having the choice is something that patents really offer.
I can only add to the importance of patents, of course. So working at an innovation office at the university, it's one of the crucial tools that we use to start a business around a research result, of course. The importance of patents also differs a lot between the different technical fields, of course. I mean, if you're going into the pharmaceutical business, it's an absolute must, as well as in telecommunication and so on. While in other technology areas like AI-driven, maybe people are leaning more towards having it as trade secrets today, their algorithms, and as we know also some of those parts are not even patentable and so. But every time when we try to commercialize something at the university, this is a starting point. Beginning at what can we protect, how can we protect it the best, and patents are always a thing that we investigate. Another aspect of this that I also want to bring up is this doesn't only concern the specific company in the sense that they get the protection or something. They're also adding to the knowledge in the world when you have a patent application published and so on. And to us at the university, that pool of knowledge is very, very important. Should also be that for smaller businesses, larger businesses, and so on, that they can seek different technical solutions in what's already done so that they doesn't need to invent the wheel. However, if we can, I would like for all of us to promote people being better in looking at information in patent databases, because we're so very used to do just a Google search or looking in the academic databases that we forget basically that there's a huge, vast sea of information in patents that we all can use for free many times.
Yes, actually, the fantastic databases, above all of the EPO, but also other offices. We have with us Domenico Golzio from the EPO, who is a former director at the EPO, who is with us today and has played such a role also in constructing these databases. So people or all of us have the trend from time to time to Google too much and not to go enough deep through the databases, not to reinvent the wheel, and also to accelerate their research. So I think this is a point that is crucial. And that brings us, Frederick, you mentioned the fact that patents are not the panacea for everything. That brings us to another question that comes now to my mind. Are patents the only key IP tools for innovation and economic growth? Can we really say they are perhaps the kings of intellectual property rights, but are they the only tools? How would you define them? Axel, yes, you volunteer? Yes.
Yeah, so this is a very good question, because most of the time people say, oh, patents, that's the right to exclude. This is great. But then if you really think from a global perspective, you need to set up an IP strategy. That's most small companies do not even consider, the full set of tools offered by IP rights. And that's the reason why we have guides on the 4IP Council website where we explain in a basic manner, very graphical style, the copyrights, the trademarks, patents, trade secrets. We even have a new one on geographical indications. If you set up an IP strategy, you need to think about all those tools and find the best way. And the combination of the different tools will create an efficient patent strategy, an efficient overall IP strategy. Most of the time, smaller companies then realize, oh, I'm going to do trade secret only. But you know what? When the employees will leave their company, who knows actually how the patent secret, the trade secret will stay actually secret or not. This is quite difficult. And having the understanding of all those tools, you have a brand, fine. You are writing code, fine. You have a solution, you have a secret, that's fine too. But you want to disclose a specific solution to the world in a secure manner, you will definitely use patents.
Yes, I think it's something quite important. I suppose Frédéric and Jan, you want to rebound on this.
Yes, so I fully agree. I think it's very important to have a holistic approach to intellectual property rights. The word IP strategy is key. It's not, I mean, it has to be approached in terms of IP strategy, starting with the intellectual assets. So what are the valuable intellectual assets I have? What are the value drivers, and how can I protect these value drivers and boost them? One example is what that I like in some startups is the combination of trademark and patent. You can sometimes you can commercialize your technology under your brand, under your trademark, but license it to others, other ones who will commercialize it under another brand, another trademark. So that's typically one example. And I also wanted to mention the importance of trade secrets. So it's often seen as the contrary of patents. I would not say that, actually. I would use the image of the iceberg. So the intellectual assets are like an iceberg, and the patents are the visible part. They protect the part that needs to be protected, the part that needs to be visible, or that has to be visible because it's in the market. But you can hide a lot behind, actually, and there's somewhere an optimal combination. Sometimes you need to patent a lot, sometimes just a little bit, but very often it's a combination of both.
And this is why in North America and in Europe, our legislators are more and more attentive on trade secrets and on the importance of trade secret. This is a very crucial point. Frédéric, you want also to...
Well, yeah, I totally agree both with Axel and Jan here. I mean, this is a toolbox. And there are also other tools, of course. You can work with agreements of different sorts and so on. And you need to consider all of them in all cases when you try to build a business around something. And I mean, different tools work differently also in different fields. So when we have students, for instance, coming to us with a new juice or something that we want to promote a healthy drink, get that out there, we're probably not working with patents right away, if that's even possible. But we work with other things like design rights for maybe the bottle and so on, or the trademark, and the branding of the whole business or the whole thing here, which is very, very important. So different tools for different purposes, for different cases. That's how we see it. And it's important not to get stuck on patents, because I feel that people, especially maybe people investing in companies, they try to focus a little bit too much, in my view at least, on the patent aspect, and they don't see the value in the brand, or even in a very well written and good design protection, for instance.
Yeah, and precisely on this, Frédéric, still patent statistics translate the important role of patents. How do you see that patent statistics translate this role?
Well, patent statistics, I mean, there's much to say about patent statistics, but I mean, it's definitely part of the business intelligence when setting up a new business. I mean, I couldn't live without the statistic knowledge, and add that into the mix of other type of knowledge about markets and those kind of things, to be able to build that big picture of how well protected the field is, who are the big actors, who's working with who. And all of those informations are in the patent information space. So it's very, very important that we as a university have access to good statistics, so we can get that, understand it, and build upon it. However, there's also a little caution here, a little warning. I mean, if we go out there, there are a lot of companies offering services, and they promise gold and so on when they can deliver like elaborate maps of white spaces to go into to patent things and so on, all based on patent statistics of different sorts. It is, in my opinion, and I worked as a patent attorney before, and it's my opinion that you never ever actually know why someone patents something, for instance. You don't know the reasons behind it. Could be that you just have a lot of resources at the time. Could be that you see that this is a really important way forward, protecting that branch of technology. But you can never ever know. And that's why you can't always draw too big of conclusions from patent statistics. So once again, you need to combine it with other knowledge also, and then you can get that perfect mix and understanding of a market, for instance.
I am sure that Jan, you want to add something on this.
Well, I agree with Frederick. I would perhaps reformulate your question into how do statistics translate the role of patents or show the impact of patents. Simply because this is something I'm working on a lot at the EPO, and I think we have solid evidence, statistical evidence of the role of patents, or at a more macro level. And actually, we just yesterday we released our latest study together with the EU IPO on that topic. So I take the opportunity. One first important message or result is that if you look at industries that make an intensive use of patents, or more generally of intellectual property rights, they are really the core of our economy, of the European economy. So in the EU, IP-intensive industries generate about half of the GDP, and patent-intensive industries, so industries that make an intensive use of patents, about 20% of the GDP, and about 12% of employment. And they have very common and important features. They have a high productivity, more impact on GDP than on employment, still significant in both, translating into high wages. They pay really high wages, higher than the average wages in Europe. And they account for the bulk of internal trade in the EU and for external trade, and they generate a surplus. So they are the industries that are exposed to the world, to world competition, that are exporting, actually, so that are driving growth. And so this is a very important message, I think, to pass. IP and patents are really in the backbone, at the backbone of the European economy, and this translates into at the micro level as well. So when you look at the company level, we see systematically that companies that use intellectual property rights or patents specifically are more performant in terms of revenue per employee. They grow faster. They are more likely to grow than other companies. And when you look at startups, so to cite one figure, a startup at an early stage with a patent and a trademark is 10 times more likely to attract investors. So there are statistics showing this, demonstrating this impact of patents. And I just would like to say last that of course, it's not because they file a patent that they perform better. They perform better because they are innovative. They develop new inventions. They market new inventions, and they need patent for that. And they do that all the better as they have patents or the intellectual property rights. But nevertheless, patents, IP are the core of economic growth.
Let me add something about this, which is very interesting. For those of you who might not know, one of the greatest tools of the EPO, which is the Deep Tech Finder. With the Deep Tech Finder, you can easily find the company on a map, so geographically. Okay, you will have all those companies having the number of patents they have filed, having easy access to the description of the patents, all the information, who are the owners, etc. So this is something, for example, that my students are using. They want to go to an innovative company. They want to know more. They go to the EPO website, Deep Tech Finder. They find right away the information. This is really a great tool. And another comment is regarding quantity versus quality. because statistics are great, but we have to be very careful. Not all the patents are equal. And if one company tries to find as many patents as possible, that might be good, might not be good. It is very important to understand that for the smaller companies, it is also expensive to find many patents. Might be better to focus on very high quality patents, something that will really provide the right protection and potentially in the future the right monetization. And that's even more true for standardization. I'll give you an example. Some companies will go to standards and will find a lot of patents, and then they will claim that they have a lot of potential essential patents covering a technology. But the truth is, you may have an essential patent covering an optional mechanism. What is the value of something that nobody? So it seems there was a glitch. So yeah. What is very important is to understand having a patent covering something that everybody is implementing is really useful. Having something that covers a specification, a mechanism that nobody implements is not that useful. So I would tend to recommend focus on quality instead of quantity.
This is a very important issue. And connected to this, Axel, how do you see the national, or perhaps first to Frederic, how does the national, international, and company race for patent materialize in this role?
Well, yeah, from my point of view, from this university point of view, if we just go back a little bit to the statistics, I think the statistics there gives you very valuable information on how the companies within that sector, how well they are doing and so on. And that is something that we look at when we actually commercialize to make a judgment of the markets and so on. And when then as you say, Axel, and also you, Jan, that the quality aspect here is then very, very important if you're going to rely on that information. And the most productive for patent quality is when the quality is high, but how can you actually judge that? Well, it's not easy, of course. The rights must be clear and the licensing must be feasible and all of those things. And there is when you actually can start relying on that data. And that is, yeah, we have trouble even judging our own companies on those measures and so on. So, yeah, statistics, good. How it materializes on that level, both national and international, yeah, it's hard to me to actually judge how well you can use that information.
Yes, Axel, do you want to add something on this?
Indeed, one of the beauty of the patent systems is we don't have one global system. So some companies may say, oh, I want to sell my solutions in one specific country, so I will first protect my solution in this country. I think it is very well understood that we need to protect. But when you really think about this, what is missing today is how to help the SMEs and the startups to enforce their rights, because many companies are coming to for IP Council and saying, oh, we benefited from public help, so to file for patent applications. And 3 years later, they got their patent. They are so proud. And then they say, but I realized that somebody is infringing my patent. So what do I do now? This is the very big question that we have, not only in the EU, that's, let's say, in Europe in general. The question is also raised in the US, but if you know that somebody is infringing your patent, what do? Do you have the money to hire the law firms to go after those? Are you able to seek for help from governments? The reality is, at least in the EU, you have nothing. The smaller companies got help to file patent applications. And once they realize that they have something valuable, that some companies are infringing, they cannot do anything to enforce their rights. I think that's one of the key priority, at least in Europe, is to help the smaller companies. They have patents, they have protected their innovation, and they need to be able to enforce their rights.
If I may, I would like to rebound on that because I think it's a very important point indeed. This is the reason why we created the Deep Tech Finder that Axel was kindly referring to. Some general remarks on that. So, I mean, we are in a world where growth is driven by innovation, by ideas, knowledge, intellectual. I mean, that's obvious. And the organization of the production of knowledge is increasingly decentralized in ecosystems, and the small businesses, startups, universities play an increasing role there. So they are very important to competitiveness, especially in Europe. So I fully agree with Axel on the importance of focusing on these small actors. And I wanted to say that in that respect, so well, in Europe we created now, after 30 years of preparation, 2 years ago, now 3, the unitary patent. So for the first time, we have a patent right that is valid in almost all of the single market, backed by a single court, the Unified Patent Court. And that's a very important step forward. That's not the final one. There are other issues, but it's very important. And we actually, part of my job is also monitoring who is using that, and the small businesses, SMEs, startups, micro entities are using it a lot. The uptake rate is very high among them, not because it's cheap. It remains expensive but because it's simple.
Yes.
And I think this is an example of what the other steps needs to be taken in Europe in terms of creating scale, simplicity, affordability for these small businesses. And a last remark, also echoing what Axel was saying, is that so there is increasing global competition for knowledge, for the creation of ideas, for innovation, and I mean it's not only the US and Europe now; it's Asia as well, and countries like China or South Korea are really at the frontier of innovation, and the patent strategies, the protection strategies, collaboration strategies need to be built at this level, which means small businesses having access to protection on a global scale.
Can I just rebound also on Axel's thing here with SMEs and I fully support that. I mean, we see that especially when the company started to grow a little bit, coming from the university, they usually don't have the resources, both money and access to expertise to help them to enforce when they have left our sphere at the university, where we can help them as professional with these questions. But then becomes the question, how can we actually help them in doing this? What are the mechanisms that we need to implement? Is it access to funds that they can use to hire lawyers? Is it access to knowledge? And then in what way? Or what is it actually that we should point to and try to develop to give them better help, basically, to enforce and defend their patents, for instance, then?
Indeed, and this is actually an issue that is not only in Europe, that is transatlantic. There is the same problem in the US. At this session, we focus very much on Europe, but at another session, we'll focus on North America and Asia. And this is something that is super, super important to take into consideration: simplicity and cost. Simplicity and cost, that are two key parameters. And I would rebound on what also Jan has mentioned in connection with the rise of new new key players such as China, the Republic of Korea, and not such a new key player, but still a player, Japan, and the new key player of tomorrow, India as well. In this respect, there are also some issues, a third parameter that enters into the game, which is research security. That now connects also in the triangle of simplicity, costs, and security. So, which is of major importance, and that may brings us to Alexander brought us already through his question in the chat, Alexander Belinsky. Before coming to his question, I would wish to move to artificial intelligence in general, and then to deepen the discussion into his own question. Do AI and tomorrow quantum technologies affect the importance of patents as a central tool for intellectual property, for let's say, economic growth in the intellectual property family? Isn't there a possible reshaping of the role of patents due to AI and quantum technologies? Jan, do you want to reply first to this?
Yes, with a quick answer, I think they confirm the importance of patents as a key tool. So it's typically what I would call deep tech, so really powerful science-driven innovation that has a huge impact on growth and economic value creation. And this is typically the kind of area where patents are important to secure, to protect the result of research, also to secure financing and the pathway towards commercialization, because it takes a lot of time to bring such technology to market. And so this translates into the patent applications we get. We see a lot of patent applications in this field. So AI obviously more. And it's interesting to note that you have what we call core AI, so innovation really in neural network, in deep learning, and then so you have that. This is what Axel also was referring to a bit earlier, and then you have a lot of applications of patents or patent applications on inventions that use AI to solve something, and that's one or two orders of magnitude in addition. These are pervasive technologies that can transform all technologies. And so we see patents used at two levels, for the core and the applications. And today, quantum is more the core, but it may come, the day of applications, broad applications may come.
Something very interesting with the quantum technologies at the moment is that we are in a gold rush moment. We know that quantum technologies are going to be big. They are going to disrupt like many sectors. We don't know exactly when, okay, because we have to be honest, but research is going fast, innovation is going even faster, and then people are filing as many patent applications as possible because nobody knows what modality will win at the end. So what sort of technology will actually enable the next universal quantum computer. So any small startup today working in this sector must really find patent applications, because maybe they are discovering something today that in 5 years will disrupt the entire computing sector. If they don't protect today, then after that will be too late. So then you have also this complementarity between AI and quantum computing. Some people say, oh yeah, AI today is big, but tomorrow with quantum computer that's going to be even bigger. Question is not exactly how big that will be, but we know that AI will help quantum computing to work faster, to become a reality faster. And those mechanisms and solutions are invented today. That's not only programming, that's enabling technologies. So classical technologies allowing the creation of the quantum technologies. And all those layers of enabling technologies are classical, reusing something that has been created 5, 10, 15 years ago. And we are reusing them today. So hopefully those companies protected those. And now they can see, oh, you know what, it was a great idea 10 years ago. We protected something we didn't really believe in, but today it is clearly making a difference.
Yeah. Yeah, AI and quantum areas of technologies are something that is very high on our agendas at university for different reasons. From my point of view at the Innovation Office, we see effects of this already on the patenting, the very fundamentals of just writing a patent applications. There are tools coming out daily that can aid and help you in doing that. And unfortunately, people, or as I should say, researchers and students, they're using these tools without even thinking of what information that they disseminate through using the tools itself. They don't know where they send the information, and they just are very satisfied with the results coming back. And then they come to us, and they have even maybe written claims and things like that that never ever happened before. But now with all these new fancy tools, they can do that quite easily. But we also see that the quality aspects of what the AI today produce, at least, is not top notch. And I think, in my conversations with attorney firms that also are using these AI tools, they've already integrated that into their workflow and so on. They're also seeing concerns of the quality aspect, since we are operating on a finite amount of data to train these tools and so on. So there is that aspect of it. Then I don't really see AI inventing a lot of things today by itself, but that maybe will come, especially when you combine it with quantum technology in the future. It can really be a powerhouse of innovation, as some person said. And then we also maybe need to think a little bit about inventorship. Should inventorship as such stay with humans, or could we include machines controlled by humans to be inventors, for instance? And all of that all those legal questions that can be asked in conjunction with this. Just also want to add one last thing. So quantum technologies, I mean, that is a big field within research today. And one of the problems that we see with an emerging technology like this is that it's very long time that goes from when they come up with something, core technology, early research, and when they can take that into the market and build a company around it. That's usually many, many years. And then we come into this problem of timing of, for instance, when to patent. Should we do that early on and risk only having a few years to earn back the money? Or should we wait and risk that someone else patent or maybe publish it in a paper? So the question is, 20 years enough for technologies like this? And is there other areas coming in the future that also have greater time spans? That is an interesting question from our perspective.
Yeah, Frederick, you have a very good point, because if you read the latest EPO OECD report on quantum technologies, I mean, you will really realize how big patenting is in the quantum technologies area. And at the end of the report, that's not a promotion, but they put a lot of effort in giving scenarios, case studies. And one is for a small startup that actually was created following the spin-off, because the university filed patent applications on something very useful. And this startup was created thanks to the help of the Technology Transfer Office. And in some countries, it is well understood, and in others, it is not. In Belgium, we have the Leuven University doing this. In Sweden, you have the Lund University. But in some countries, they barely use this type of innovation. And it creates a lot of jobs, and it helps the students to start right away. They have something that they can really rely on right away. So that's very, very important.
And this is very much connected to the question that Alexander Belinsky has raised, and to which, in part, Frédéric has touched upon. Do you think that inventions created primarily by AI, without contribution of a scientist or an engineer, that have economic significance should get patent protection by changing the law? So how does granting patent to AI create invention, which is not possible today globally, shake the patent system and the role of patents? Example of such AI created inventions, new molecules or proteins, de novo protein for treating disease. This is an issue that has shaken a lot also the academic community, with the famous Davos attempts by Stephen Thaler. So, of course, the reply, we cannot reply now because there is no law for this. There is one jurisdiction in the world, in the southern part of the world, that seems to be more favorable to it. But apart from this, we are in no law, not a no law world, but we have no global reply to this issue. Axel, Frédéric, Jan, do you want to reply to this question?
I can venture a word.
Yeah.
So actually, as the EPO, the role of the EPO is not to advise on what should be the law. We just have to apply it. So I will not comment on should. Simply, we by applying the European Patent Convention, we consider that any invention has an inventor, and I think that in practice, even AI accelerated inventions are piloted by someone, and there's a decision to file a patent application. But I would make a more general comment. I've been in the world of patents and economics for now quite a while, and it's not the first time I have a question like that. So I think that the general question is, should we have a one-size-fits-all patent system, or couldn't we imagine a smarter patent system that would be adapted for different types of technology, with rules for pharma, rules for mechanical industries, etc. So as a very general point, not as a EPO, but as an economist, I see the value of having one rule, which by historical experience is quite flexible, quite plastic, and has been able to cope with quite different waves of technology. So that would be one remark. I think then when it comes to AI, it has a lot of impact on our life. So I think it dramatically changes the way of innovating. It's very useful on that side. It's also very useful on our side. Actually, we use it a lot. We make productivity gains. We can improve the services we offer, and it changes also because it accelerates all of that. It changes the rule of the game. Obviously, the man skilled in the art today has an AI. Actually.
Yeah. So that's a really interesting question, and in my one of the IPR courses that I have, roughly 350 students each year, I have the latest, I think, 3 years asked that question. So after presenting, so the students have a fair good knowledge about the patent system. We talked about software, AI, and those kind of things. Then I asked the question to see what they think. And for the last 3 years, the message from the students have been very clear, that they could very well see that you could do something where man-machine together is considered to be inventors. That is the message from the students. And if that is an indication of where we're going, then I would say that probably not tomorrow, maybe not even in 10 years, but forward, I think we will need to change the law to deal with that scenario in some way. And I think it will only get more and more critical to start working on this, in a sense, since quantum is coming, AI is getting better and better. The question will be higher and higher up in the politics arena and so on also about this, driven by some companies, I guess.
I would like to try to turn around this question, because we hear a lot about, you know, inventorship and I like this angle, but let me try to turn it around that way. AI today is a tool, and it is a great tool. And now you have some services that rely on AI-based tools to facilitate prior art research, which is very important for the smaller companies. That also allows companies to say, I have filed a patent a few years ago, and can I use an AI tool to help me to find if actually my patent is infringed? Or if my patent could be licensed to other sectors, maybe my patent is useful by a different industry, in a different sector. And today, thanks to AI, we can really accelerate this type of research. So facilitate the monetization, facilitate the prior search. That's all this type of usage that I strongly believe in, that AI will help not only the smaller companies, but also the big companies. So before thinking of, is the AI going to be the inventor? I would say today's tools relying on AI really facilitate the life of innovators.
Yeah, but don't you think that it's already, are we not already there? Do you think, Axel, or what's your perspective on that?
I know one company that is contributing to 4IP Council that is having these specific tools dedicated to helping companies to find ways to apply their patents. So they say, oh, just an example, you have filed this patent to cover a specific mechanism for telecommunication. That's great, but maybe another sector is using this. And then they use their AI engine and then say, oh yeah, you know, the casino industry is using, in a security manner, the same mechanism that you created 10 years ago to do something different. Boom. Then you can find potential licensees. So I tend to believe that there are many cases where we don't even know where AI will help us, but I strongly believe that it will facilitate our lives.
Yeah.
And I think this is
very,
sorry, Jan?
No, I also agree. And I would just add that it's also patent offices have a role to play there, because there are services that we can leverage AI also to improve our services. And so this is what we are striving to do. For instance, we have a legal interactive platform for this purpose, and more is coming.
Yeah, precisely. This was connected to the question I wanted to raise to all of you. The European Patent Office has embarked, together with the other main important offices in the world, the 5 offices, in plans to use AI in various stages of operations and analysis. And clearly enough, the European Patent Office has been considered worldwide as a model for quality in patent granting, and actually as a major success of the European construction. This is one area which is not discussed, whereas there are so many discussions on the European constructions that may go this way or that way. There is no discussion on what was created outside of the EU, but much connected now to the EU is the UPC, on its success. How AI tools may influence this development. My question is perhaps more to Axel and Frederick than to you, Jan. So the acknowledgement is worldwide. US commissioners have acknowledged the excellence of the EPO. Other US commissioners for patents or other administrations in the world have always commended the the forefront role of the EPO. How do you think, fear, or hope that AI tools, this time not AI patents, but AI tools, will support, improve, damage this beautiful construction?
I like to see. I like to see the EPO as an ecosystem. You have the EPO facilitating patent application with all their tools, their database, everything that they have developed to facilitate, for example, the interconnection with the standards development organizations. You know, easing the work of potential inventors is great. Then, part of this ecosystem, you have the UPC. You have one court to really enforce your right, and based on this, it facilitates the life of the inventors, the patent holders. And then you have the PMAC that had just been announced, facilitating the mediation, helping licensors and licensees to actually find a solution. So this entire ecosystem, 20 years ago, back in the days, I could hear people saying, oh, it is segmented, it is fragmented, it is too complicated, we cannot find information we are looking for. But today, you go on the EPO website, you get everything: education, knowledge, connection, help. And at the end, you cannot complain that you cannot find information. They're just 2 or 3 clicks away. So yes, I'm very proud of what the EPO is doing, to be honest. And I recommend all the small companies, you have questions, first go to the website. You will learn. And then you can even have a human being. So your question about AI is very interesting. I believe in the human expertise. I know that when a patent is granted by the EPO, humans have carefully assessed and made the right decision.
Yeah.
Well, I think time flies, and perhaps it's already 5 p.m. in Europe, in CET, and as such, I would wish to ask each of you for your takeaway from this Global Digital Encounter. What should we remember? What's the message in one word or in one sentence that you would wish to pass to our distinguished audience which is live now, or the thousands of people who watch afterwards this Global Digital Encounter? Jan?
Thank you. So I think my feeling after this discussion is that we have a huge responsibility in ensuring that the patent system works well, because it's important and expected by the economic actors. So from the perspective of the patent office, I would say fundamentally, we are dealing with prior art. Prior art is global, so that's our challenge to mine this data. And so there is a huge potential also of AI there. So not directly visible in the services, but more in the back office. That's very important. There's a lot that is being done, and a lot we can do more. And in that context, prior art is global. And so I just wanted to remind this dimension. We are an office for Europe. Then there are some innovative prior art is coming from everywhere. So our challenge is to have access to that. There are positive spillovers or benefits between the patent office and cooperation is very important in that respect.
Very much. Axel?
Well, I will leave Frederick first.
Yeah. Okay, so I think one takeaway here is that patents are not dead. I've seen someone say that, or that it will be dead in the area of AI and so on. I don't think so. I think it's more important than ever as a tool, as we have discussed. And AI will only enhance that in so many ways. So patent will stay on and be very, very important for all businesses for the foreseeable future. Yeah.
So my conclusion is intellectual property rights are misunderstood. And unfortunately, sometimes it is easier to try to confuse people about IP and especially about patents than anything else. So people realize patents are terrible. They are blocking innovation. They are hindering the innovation, but that's the contrary. Without the patent system in the EU, I'm not sure what the EU will produce. And I have to be very honest. We have to rely on the European patent system to go faster, stronger, and everything works as it is today. We don't need to change it. We need to get together, join forces, and make sure that everybody can benefit from it. And I'm confident we will succeed thanks to a strong patent system.
Well, thank you very much for these takeaway messages. I have one that I would wish to share with all of you. First of all, well, I have two. First of all, we have not exhausted at all our agenda on discussing on patents and its role for economic growth. And for sure, in the coming months, we will do a second Global Digital Encounters with our distinguished speakers if they accept so that we continue this discussion. Secondly, we on purpose focused on Europe, though giving a worldwide dimension, because this was the idea for this first encounter on this economic role. We shall for sure as well make a global digital encounter that considers the same questions from transatlantic and Euro-Asian perspective very soon. So this is the sense of the message I wanted to pass together with my three esteemed co-panelists and colleagues. We thank you so much for your attention, for those who are present live. We thank in advance the thousands of academics, researchers, students, professionals who will watch this Global Digital Encounter. And I would say goodbye until our next Global Digital Encounter very soon, very much focus in the start of the year in the complex international environment, very much focused on technology and on the role of patents. Thank you very much for your attention. This Global Digital Encounter is now closed. You will receive within 48 hours or something like that the audio and the video. So the video and audio of the today's encounter. In the coming week, you will receive also a short report on the encounter itself. And of course, our team is next to all of you, to all speakers, but also to all our audience, to construct together and to build together our discussion on the future of IP in a changing world. Thank you.
Thank you.
Thank you.
Thank you.